SJC-11625, Michael J. McCarthy and others versus the Governor of the Commonwealth and another.
Mr. Pellegrino, when you're ready.
Thank you, Your Honor. Rayford Pellegrino on behalf of Michael J. McCarthy and Mary Ellen Manning. This matter that brings us here this morning is in regards to, as we understand, Attorney McCarthy is the only person in the history of the Commonwealth to receive the favorable advice and consent of the council. And as I use the word council, I'm referring obviously to the Executive Council, 4-3, as recorded in the register, and has not received his commission. This has gone on long enough. Attorney McCarthy is entitled to his commission. On August 23rd, 2012, the governor nominated and appointed Attorney McCarthy to a position in the judiciary when he requested the advice and consent of the council.
Well, how could he appoint them before he got the advice and consent of council? Nominated, yes, appoint.
The governor's role of nominating and appointing was complete at the time he submitted to the council, except for the ministerial act of overseeing an assembly of the council if he was present.
So there's a hearing before the council, and information comes out that may be disturbing to the governor, but the council votes anyway. It's too late. Too late. The governor can't say, I'm not going to go forward with this and actually do the appointment.
I would suggest to you he can't for two reasons. Number one, and you're dovetailing a little bit into the 1906 case. If you allow me a moment, I will get to that. But we should view this similar to the federal system. But on October 17th of 2012, that's the time when the entire nomination appointment became complete or ratified, if you will, when Councilor Manning registered her favorable advice and consent by way of letter to the governor and signed the register. So at that point, the only competent evidence we have is the register, Your Honor, which is required by the Constitution that the councilors maintain. In 2013, and this is confirmed through a memorandum from the Attorney General's office, which ironically was issued while this case was pending, in which the memorandum was for potential applicants to the judiciary, in which it said that the governor's office states the effective date of the appointment is the date of a majority of the council provides its favorable advice and consent. That would be the October 17th, 2012 date. So as of that point, the process became complete, except for the ministerial act of the secretary notifying the appointee of his appointment and the oath of office. Now, this process under General Law, Chapter 30, that the secretary advise the appointee of his appointment is clear. The law is clear. Yet, despite this, the governor's practice has been that the governor or his legal staff notifies the nominee of the appointment, despite this clear statute contrary to that. Now, because Attorney McCarthy was never notified of his appointment as a nominee, he couldn't possibly comply with General Law, Chapter 30, Section 12, because within the 90-day period, the Secretary of State's office, for whatever reason, I'd suggest to you it's irrelevant at this point why they didn't notify him of it. They didn't, and that's clear. The courts, is going back to 1703 in Ashby versus White, found that for every wrong there's a remedy. And 100 years later, in 1803, in Marbury versus Madison, the courts defined that as it relates to this case when they said a commission withheld to an appointee is a deprivation of that legal right. It couldn't be more clear that Attorney McCarthy's legal right to that position has been denied, wrongfully denied, I would suggest. And this court has the power.
Can I ask you, counsel?
Yes.
Why did Attorney McCarthy wait if he thought that everything was settled after the letter from Mary Ellen Manning changing her vote from abstain to for him. I mean, if that was the settling event, why did he wait until the governor renominated him, second hearing, and nothing happened to go back to what had happened earlier? I don't
think-
get that.
Yeah, I can only tell you this, that whether he chose to wait and thought that the matter might be cleared up through a second nomination, which had no impact on the first nomination, it's clear. The governor never withdrew his initial nomination and appointment, ever. It's irrelevant, and this is a little departure from where we've come. I think for purposes of the vehicle for this court to get to where it needs to correct this wrong, we don't have to get to the issue of who he was sworn in and why he was sworn in, because clearly, I'll concede, it was beyond the 90 days. What we do know is that the Secretary of State failed to comply with its statutory and constitutional requirements to notify the nominee. And we know that that's a deprivation of someone's legal right. So it brings us back.
Was there ever any inquiry about where's my commission? Did that ever happen?
Excuse me. Yes, there was inquiry. There were communications between the governor's office and Mr. McCarthy, or on behalf of Mr. McCarthy. And the only indication that I've seen from the record is that there was no immediate solution for the matter from the governor's office. That was during the time period after the initial appointment, nomination appointment before the second one. But I think that takes us down a road that really isn't directly relevant, because this court has the power to issue an order in equity, nunc pro tunc, as it relates to the secretary, which brings me to the issue brought up by the AG's office that, wait a minute, this court doesn't have the power in mandamus or in declaratory relief to order the governor to what they argue is fulfill a discretionary act. I'd suggest to you this court clearly has that power as it relates to the Secretary of State to enforce the Secretary of State, empower the Secretary of State in equity to comply with the statutory and constitutional requirement to notify the nominee of his appointment.
Going back to the constitutional provision.
Yes.
It says all judicial officers shall be nominated and appointed by the governor. He was nominated by the governor. When do you say he was appointed by the governor?
His nomination and appointment by the governor was August 23rd, 2012.
So you're saying that the governor's nomination prior to advice and consent is also an appointment?
I am saying that, and that's supported by the 1906 case of the opinion of the justice, which is referenced to Article 9. And in that case, it makes clear that the requirement for the nomination shall be at least 7 days prior to the appointment, which gives time for the council to consider the matter and act upon it.
So that this language is surplusage, that it could just as easily say all judicial officers shall be nominated by the governor, and there's no need to add the word "and appointed"?
No, I think it's very important, nominated and appointed, because the
That the governor can't appoint somebody until the governor's council blesses the appointment.
Well, I think that if we look at the 1906 case, which gives us great guidance, the 1906 case dealt with the governor's ability to pardon someone and said that the governor has the ability, his sole discretion, to go consult with the council and seek their advice before he decides if he wants to submit to them for a pardon. Similarly, the governor has the ability to go consult with the council before he submits a nominee as a polling, if he chose to do. He has the right to do that. And he has the right, if he goes in and it doesn't sound like it's favorable, or it sounds like it's favorable, he has the absolute discretionary right to not submit that person for nomination or appointment to the council. However, once he nominates and appoints, puts it before that council, unless he withdraws it before the council acts, that nomination appointment is ratified at that point. Otherwise, why would we have the language in the Constitution, and this is the key word, by and with the advice of counsel? You have to disregard the word by in order to come up to the conclusion that there's two discretionary acts of the governor. If you look at the 1906 case, it talks about a single affirmative act. There is nothing in that case which gives rise or interpretation that the governor has essentially two discretionary acts. One would be at the time he submits it to the council, and the second one would be after the council gives its advice and consent. let's assume, arguendo, that the governor, if you follow that process, the governor submits it to the council, the council gives its favorable advice and consent, and the governor decides, no, I'm not going to, under that theory, complete the appointment process, take the next step, the second discretionary act. You've essentially gutted the empowerment of the governor's council, which there was an amicus brief filed in this case that goes back to 1621, talks about how did this come about? It came about because there were people traveling in from different areas. There was the thought process, someone from Maine is not going to travel all the way down to come into act upon that, and that's more into the procedural aspect. But if you take the reciprocal now, the council says no, and then they allow, and then the governor says, at that point it's dead. The governor's not going to appoint. But there's nowhere in the 1906 case, in the Constitution or anywhere else, that empowers the governor a second discretionary act. What also is extremely important is that, and I've talked to you for a moment about it before, the Article 5, which is the registry.
I'm afraid your time is up, so I'll give you one last sentence, but then we need to move on.
The last sentence I would say is simply this, is that this is a constitutional issue. The Constitution and the Articles are clear, the Pineo case, that this court cannot violate Article 30 of the Declaration of Rights and dictate or in any way, shape, or form suggest to the council, the governor, how they're going to conduct their business in a formal proceeding. That's up to them. History shows they've done it their way. And in fact, the examples we've given in this case show that they've done it their way. As much as we all have parliamentary instincts from our upbringing in this society, you have to, I'd suggest, put those aside and recognize that only the council and the governor can set those rules. They haven't done it. Therefore, past practices set the precedence for how the governor's council acts.
Can I ask one more question?
Yes,
Thank
of
you.
course. Wait, one more question.
I take it the governor didn't sign a commission here. Governor has to sign a commission, right? I have a commission in my lobby.
The commission gets issued, as I understand, from the Secretary of State's office.
Not signed by the governor?
I'm sorry?
It's not signed by the governor?
It may be signed, but that can't happen until the Secretary of State acts. And whether by mistake of law of the governor here didn't.
You're not a judge until the governor signs the commission following the advice and consent of council.
Right, but the governor was under the mistaken belief, I would suggest.
So can we order the governor to sign the commission?
No, the point, that's a ministerial act, and I'd suggest that.
And order the governor to sign the commission.
On a signing commission on a ministerial act, yes, you could. There's
do
nothing, that's not precluded in the court of equity to issue the commission first, the 90 days, then the person takes the oath of office. And that's the process that should be followed. That's a purely, in the court, in the different cases, both Scullin and Pineo talk about it, the ministerial act of what happens after the nomination and appointment occurs, they're ministerial, purely
So
ministerial.
we can order the governor to sign a commission.
I would suggest, Your Honor, that you can. If you find first that the nomination and appointment was complete.
Right.
All right, thank you.
Good afternoon, Your Honors. Joanne Shotwell-Kaplan for the appellees, Governor Patrick and Secretary Galvin. Nomination and appointment cannot be the same act. The Constitution specifically, expressly says the governor shall nominate and appoint by and with the advice and consent of the council. It specifically provides that there must be 7 days, a 7-day interval between nomination and appointment. The 1906 case is consistent with the fact that the appointment must be a separate act of the governor alone. There is a long line of opinions of the justices of this court and decisions of this court spanning from 1906 through 2012 that says that in a variety of ways. The cases say that that the governor must personally both nominate and appoint judges, that a judicial appointment is an act of the governor and the governor alone, that the council's role in judicial appointments is not as an actor at all, but purely advisory and consists of considering and passing judgment on a nominee, not an appointee, that council consent must come before an appointment or appointment after council consent, that the council's opinion cannot relieve the governor of the duty of deciding, and that appointment is both the initial and the final responsibility of the governor, resting on his discretionary judgment, even theoretically entailing the right to decline to appoint after the council has given its consent. And the 1906 opinion expressly discusses that very scenario and says in no uncertain terms that even if that occurs, there still must be a separate appointment by the governor. The federal system is not to the
So your view,
contrary.
going to Justice Cordy's point, is that the governor could learn something during the governor's council's hearing, which may not deprive the person of the majority vote of the council, but could cause the governor to say, I don't want to go forward.
That's exactly right, Your Honor. Or information that comes to the governor's attention simultaneously. Perhaps the lieutenant governor is presiding over that council session, doesn't know how the governor would react to that information. The governor does have the ability, the discretion at that point, to make a final decision, and the federal system is not to the contrary. Marbury versus Madison specifically says that even after the Senate has given its advice and consent, there must still be a presidential appointment, which takes place by virtue of the president signing the commission. So there is no difference in our long line of cases that establishes as much, and there simply was no appointment here, and as a result, the secretary could not and may not issue a commission. There also was no council consent here in any event, because the Scullin case, interpreting the Constitution, holds that the council must take a formal vote in a council session, that it is the governor who calls the council into session and controls when the matter is before the council for a vote. That occurred here on September 26. It was a tie vote, thereby defeating Mr. McCarthy's proposed appointment. And their arguments all depend on giving improper weight to a subsequent letter by a single councilor 3 weeks after the council session, when there was no need to withdraw the nomination. The nomination had failed to achieve confirmation at that point from the council. And in fact, the lieutenant governor had informed the council on October 10th, and this appears in the minutes of that meeting, that the governor had not decided whether to resubmit the nomination to the council, thereby clearly establishing on the record of the council that the matter was no longer before the council. It's a week later, outside of a council session. The matter isn't even on the agenda for the council on that date, when Councilor Manning submits a letter. If that kind of unilateral action by a single councilor could undo what the council has done, then you would violate the provisions of the Constitution that specifically say that it is the council that gives its consent. And the Scullin decision says that means it's acting as a board. It must act with a formal vote at a council session.
Could have been raised again, as are you suggesting, at a subsequent council meeting after then Councilor Manning had registered or attempted to register, indicating a change in vote. Could it have been ratified, so to speak, at a subsequent hearing and recognized as such?
If the governor called the council together into an assembly and renominated Mr. McCarthy, yes, there could be another vote at that point.
Not merely.
I'm sorry?
There would have to be a renomination?
Yes, because as the 2012 opinion of the justices indicates, the action on the prior nomination was complete as of when a vote was taken and it was voted down. So it's clear there was nothing more to be done by the council at that point but for the governor renominating. And of course, we do not know what action the other council members would have wanted the council to take on October 17 or any other date. This is why it's important that the council act as a body. They have the ability to engage in dialogue, to try and persuade each other, to perhaps change their own votes based on a new vote or a changed vote of another council member. So this upholds the role of the council, contrary to the suggestions that this is somehow inconsistent with its role. To the contrary, it upholds the role of the council as a body and ensures that that role can't be defeated by unilateral subsequent action by a single councilor. Finally, the oath, General Laws, Chapter 30, Section 12, specifically indicates that the oath of office must be taken within 3 months of the date of the appointment. It does not speak in terms of dating that from notification. And of course, Mr. McCarthy knew of Ms. Manning's letter. He was CC'd on the letter. That is what he purports to have been his appointment. He had 3 months from that date to take the oath. He did not, and by the plain language of the statute, his appointment is therefore, his purported appointment is therefore void. So we suggest that to the extent you reach the merits of this matter, there are multiple bases on which to affirm the single justice's decision. We have suggested that the matter is moot, and that's because subsequent to the single justice decision, upholding the governor's view and the secretary's view that there was no appointment here, the governor, with the unanimous consent of the council, meeting in a council session, has filled the very position for which Mr. McCarthy seeks a commission.
But if your brother is right, that position was already filled.
Yes, but that would not alone allow a commission to issue, I suggest, Your Honor. I understand the question, but there'd be an independent question which is not raised in this lawsuit and would take a new action with respect to when title vests. I don't believe we have a decision on the state level with respect to that. At the federal level, Marbury versus Madison indicates that title does not vest until after the president has signed the commission, the Secretary of State has affixed the seal and recorded, thereby issuing the commission, whether or not it ends up actually being delivered to the appointee. The equivalent steps on our end take place after the oath is taken, and therefore the individual is qualified, and the Secretary of State issues a commission that does bear the signature of the governor. That hasn't happened. It happened already with respect to Judge Rhoda, who is already serving. He's been serving since September. The issue would be who has the superior claim to title to the office. That's a brand new lawsuit, and there's no indication that Mr. McCarthy plans to bring it. But in any event, that's not an issue in this case, based on the fact that there is no position open for a commission to issue for at this point. This case cannot result in the relief requested, and for that reason, we've suggested it's moot.
All right, thank you.
Thank you.